to begin by acknowledging the traditional custodians of the land on which we work, the Wangal people of the Eora Nation. We recognize their lands were never ceded, and we acknowledge their struggles for recognition and rights, and pay my respects to the elders, past, present, and the youth who are working towards a brighter tomorrow. This continent always was and always will be Aboriginal land. Hello, everyone. I'm Mubashir Hassan, your moderator and the host of the webinar today. This is the second webinar in a three-part series on Magnitsky Act, jointly organized by the Diplomacy Training Program DTP and the New South Wales Service for the Treatment and Rehabilitation of Torture and Trauma Survivors, STARS. Before I introduce our speakers, here are a few housekeeping notes to help the session run smoothly. Please keep your microphones muted throughout the discussion to minimize background noise. Feel free to submit your questions at any time using the Zoom chat box. We welcome your engagement and we kindly ask that questions remain respectful and relevant to the topic. Reference materials related to the discussion will be shared in the Zoom chat during the session for your convenience. And this session is being recorded. The recording, along with any shared material, will be made available to the participants after the webinar. So I'd like to begin with Phil Robertson Jr., Director of the Asia Human Rights and Labor Advocates. Phil brings a wealth of insights from his 15 years as Deputy Asia Director at the Human Rights Watch, where he worked extensively across Southeast Asia, a region where authoritarian governments often operate with impunity and human rights violations are rarely met with accountability. Phil, obviously, we now have a very different administration in Washington. With President Trump back in power, his foreign policy instincts and approach to global human rights enforcement, especially through mechanisms like the Magnitsky Act, are once again under scrutiny. So my first question to you is, how do you think President Trump is going to use the Magnitsky sanctions in Asia? What indications do we have so far of how his administration might engage with human rights offenders in the region? Over to you.
Well, Arshar, thank you very much. I prepared a longer discussion about the issue of Magnitsky sanctions, which I'll discuss, and I'll cover that question as I get to it. I think it's important to understand that the Magnitsky sanctions that we're looking at here are ones that have been the result of a long battle, hard efforts by the international human rights movement to bring these Magnitsky-style sanctions to life. And we recognize they're important because they're able to target specific individuals and entities. Australia, for instance, an excellent example of the kind of battle that was required, where the legislation was really pushed through Parliament over the objections of many in the Australian policymaking circles, especially those at DFAT, who I think were seeing it basically endlessly talking to people behind closed doors as somehow magically resulting in a progress on human rights. And we just don't see that. There were similar struggles taken to pass these laws in the US, UK, Canada, and the European Union. Those are the major countries with the Magnitsky style sanctions. For instance, President Obama strongly resisted passage of the 2012 Magnitsky law in the United States, and actually the US Congress had to tie passage of that law to the lifting of Jackson-Vanik restrictions on Russia and Moldova to get Obama to finally agree to sign the law. Now, I mean, Magnitsky sanctions are really important for several reasons. They're targeted sanctions. They respond to some of the serious lines of criticism that have been made in other cases. For instance, the comprehensive sanctions like those that were imposed on Burma or Myanmar, if you like to call it that, in the 1990s. The argument back then was that the entire people of Burma were suffering under tough economic sanctions because of the actions of the military, and that there were humanitarian implications for that. I don't entirely agree with the sort of argument against comprehensive sanctions, but I understand that that argument was used very effectively by companies and government officials who didn't really want to impose sanctions, and was used in a way to sort of push back on sanctions. And Magnitsky sanctions, because they're targeted, because they're specific, really calls the bluff of those who claim that sanctions should be more nimble and more targeted. They really do focus on that. And because these sanctions hit key abusers in their organizations and companies through financial and economic sanctions, asset seizures, and travel bans, the argument is that they're more efficacious. That's one of the things we need to test. That's one of the things we need to look at when we actually talk about Magnitsky sanctions, because if you look across the Asia Pacific region, in many cases, it's not necessarily clear that they are more efficacious than comprehensive sanctions. There's a number of reasons why that is, but let me move a little bit from the issues of implementation towards looking at what we're facing in particular countries. The case of Magnitsky sanctions in Bangladesh. This is probably one of the best examples where there were, in fact, important progress made on the ground because of the Magnitsky sanctions. The Magnitsky sanctions were imposed on the Rapid Action Battalion, known as RAB, and some of its key commanders on December 10th, 2021. And when those sanctions came in from the Biden administration, I think it caught just about everybody in Dhaka by surprise, because for years the RAB, which is the Joint Police Military Force, had been a byword for impunity, enforced disappearances, and violence through what were termed crossfire killings. People would be detained, interrogated, and tortured, and the RAB would then claim that they were taking them to a so-called scene of their crimes where the suspects' compatriots were allegedly hanging out. They would open fire. It was claimed that those compatriots opened fire on the RAB, and then the person who was the suspect in custody was killed in the following crossfire. This was all really sort of made up. It was like the sort of bad Hollywood films shot while trying to escape excuse, and no investigations would take place. And so you got to the point where, when relatives of someone who was disappeared learned that their loved one had been taken by the RAB, they would conduct a preemptive press conference to plead with RAB not to kill the relative. When the RAB got hit with these sanctions, it was a real wake-up call. I mean, Human Rights Watch had correctly called them an official death squad. It called for them to be disbanded. When I was working there, we got nowhere. Despite extensive evidence, we published 6 reports on RAB between 2006 and 2021, and officials denied everything, including in a meeting that I had in 2011 with the actual Minister of Home Affairs at her office. We spent a lot of time also trying to persuade Western donors to stop providing training, equipment, and support to RAB. And that was the key piece that was impacted by the Magnitsky sanctions, because when the RAB itself and 6 senior current and former commanders were sanctioned with a very, very strong line of reasoning from the U.S. government, it all of a sudden had everybody take a second look at RAB. And that was important. That was critical. That was, set out a new reputational price that was placed on working with RAB. And it served to diminish the support that they were receiving from other governments, because there was many of the governments who viewed RAB as being the one place where they could provide training, and that it was an effective policing force. In fact, our argument was that it was a death squad. But what we saw coming out of that was also that while the U.S. acted, none of the other major governments acted in terms of imposing Magnitsky sanctions. Not the UK, not the Canadians, and not the European Union. And this has been a continued problem, that there's a failure to multilateralize these Magnitsky sanctions. And that has created problems. That has created significant issues, because Human Rights First study of the first 5 years of Magnitsky sanctions, looking at the US, UK, EU, and Canada, found that only 11% of the sanctions persons or entities were sanctioned by more than one country. And so what you have is like a failure to coordinate between these various different governments who have Magnitsky sanctions to impose them in a coordinated way on persons that are believed to deserve to be hit for either human rights or corruption reasons. And the other issue, and this is something that also involves Bangladesh, is that these kind of sanctions are not being used nearly as much as they should be in the Asia Pacific region. Rather, what we've seen in many cases, the most obvious situations like Russians involved in the invasion of Ukraine, or Iranians or top officials in Belarus who are behind the crackdown there, get sanctioned. Human Rights First found actually in the report that they put out that there were very few Magnitsky cases focused on South Asia, with Bangladesh being perhaps the most prominent one. Only 3% of the total U.S. sanctioned cases were on South Asia. Only 2% of the UK cases were on South Asia. And there were no cases involving South Asia from Canada or the EU. So again, it seems that there's a lack of effective coverage that looks at these kind of issues. There's a lack of effective follow-up. And even in cases where, for instance, there are numerous groups working together, numerous countries working together, for instance, in the case of Xinjiang in China, where, top officials involved with the China democide have been identified and sanctioned. And, the top 4 Chinese officials were sanctioned by all 4 of those previously mentioned governments who have Magnitsky sanctions. The targeting is difficult because these are people who certainly are should be sanctioned, but the bottom line is that they don't have assets in the U.S., UK, European Union, or Canada. They don't plan to travel there, and so effectively they're sort of beyond what these sanctions can impose, and so that's another significant problem we've seen. The issue of Burma is another area where there's been significant sanctioning. But again, we can argue that the situation has not really improved directly as a result of those sanctions. I think that it's important to identify those people who are in fact involved in these issues, who are involved in these abuses. But again, is the efficacy that we expected from the Magnitsky sanctions being seen as a result of those imposition of sanctions? And I think you would have to say that it's definitely a mixed bag, where we have in Myanmar an ongoing civil war, where we have certainly people who have been targeted, like from Senior General Min Aung Hlaing, the head of the military junta there, on down. But again, not much has been seen in terms of direct impacts from the sanctions. You asked a little bit about the Trump administration, Mubashir, and I wanted to get to that because there has been a sanction that has just recently been imposed against a senior Karen commander of a border guard force, a guy named Sawchit Tu, and his 2 sons, and the actual border guard force that he leads. And in fact, this is a person who has been providing effective protection to the massive online cyber scamming and human trafficking syndicates, largely controlled by Chinese individuals at that border. It was when it hit in March this year, which was one of the first instances of the Trump second term using this authority. It certainly was applauded by many people here as an overdue sanction, something that needed to be done. But I think ultimately, again, it's one-off, and we've seen a similar action by 1 or 2 other countries towards Sawchit Tu, but not enough, and certainly not enough to prompt Thailand to take action and really try to cut him off and cut off his armed group, which is heavily reliant on cross-border supplies and assistance to continue to operate. The issue, I think, of these scam centers is very important. There's been a recent report that came out. Hold that up just for a second. which looks at policies and patterns, state-abetted transnational crime in Cambodia as a global security threat. And I think it's important to recognize that when we talk about Magnitsky sanctions, it's hard to go after, for instance, the Burmese government with Magnitsky sanctions, or it's even hard to go after the Hong Kong administration, which was done in 2020 after the national security legislation, where 11 people were listed for Magnitsky sanctions there, all the top people in Hong Kong and in the Beijing liaison office to Hong Kong. The impact is not enough, but perhaps Magnitsky sanctions could be considered by the Trump administration going after these criminal networks that are operating in Cambodia, Laos, and the Thai-Myanmar border, scamming people around the world, using literally hundreds of thousands of trafficked persons across those three countries. It's surprising to hear, but it is hundreds of thousands of people. It's not just tens of thousands, but the figures are quite clear from the UN and others. And so perhaps what we need to be looking at is how are Magnitsky sanctions going to be effectively pushed and coordinated, worked through with NGOs and other groups that can sort of help with the targeting and ensuring that they're much more effective. And so far, with the exception of Bangladesh, where there was a direct impact in terms of damaging the reputation of the Rapid Action Battalion and making them more accountable, we've not seen the kind of efficacy in the Magnitsky sanctions that I think many of us hoped when we were pushing for them to be implemented about 10 to 15 years ago when we were passing the legislation. Finally, I would say that Australia's Magnitsky sanctions so far have been quite a disappointment. Other than going after Burma, which is helpful, almost nothing has been done in the Asia Pacific region. And again, it appears that the Australian government is reluctant to go after trade partners or allies, not willing to sort of follow the facts, regardless of the political consequences. So I know I'm probably at time, and I'll leave it there, but I'm happy to answer questions further as we get into the seminar.
Thanks, Phil. I had a follow-up question, but you already answered it about what are the other targets that Trump administration should go after if they're concerned about scam centers targeting US citizens. And I just also want to say that I'm gonna bring our second speaker, Elizabeth Wood now. And Elizabeth Wood is the CEO of Capital Punishment Justice Project, CPJP, an Australian-based NGO that stands for a world without death penalty or other forms of state-sanctioned killing. CPJP's work includes advocating for governments with Magnitsky-style sanctions laws to utilize these schemes to achieve accountability for extrajudicial killings and enforce disappearance. And Elizabeth and I would also go a bit deeper on the Bangladesh case. So welcome, Elizabeth. Could you start by introducing the work of CPJP and sharing why CPJP supported the adoption of Magnitsky legislation in Australia?
Sure. So thank you for inviting me to participate tonight. As Mubasher said, I work at Capital Punishment Justice Project, or CPJP, based here in Australia. And so CPJP was established in 2001, formally under the name of Reprieve Australia, and has a long history of advocating for the worldwide abolition of the death penalty and providing assistance to support people facing the death penalty. In more recent years, our remit has expanded to include other forms of state-sanctioned killing. And since late 2022, we've run a project focused on Bangladesh that seeks to achieve accountability for extrajudicial killings, enforced disappearances, and torture, as you mentioned. So as part of this project, we host data on our website about enforced disappearances and extrajudicial killings in Bangladesh, covering the period from 2009 to 2022. This data was used in an excellent interactive article called Body Count that was produced by Netra News in late 2023. And that showed the scale of extrajudicial killings, custodial torture, and fatal shootings, which Phil spoke about earlier, referred to as crossfire deaths. And it showed that security forces had killed almost 2,600 people during the time covered by the data set. And as Mubasher mentioned, the relevance to this webinar is that a key aspect of our project includes advocating for governments with Magnitsky sanctions legislation to use these schemes against perpetrators in Bangladesh. So Australia's Magnitsky sanctions were introduced via an amendment to the Autonomous Sanctions Act 2011 and came into force in December 2021. And while there are debates about their use and effectiveness, at CPJP, we are choosing to continue to view them with optimism. Australia's adoption of such legislation signalled a commitment to human rights and to holding perpetrators of violations to account, particularly in allowing for specific individuals to be held responsible. And really importantly, for the victims of such abuses and for their family members, it says that what happened to them was wrong and that there should be consequences. And this is particularly significant in circumstances where the authorities in the state where the human rights abuses have occurred are responsible, complicit, or otherwise unwilling to bring the perpetrators to account. And so our work on this project is led by a Bangladeshi human rights defender, Muhammad Ashrafuzzaman, who has not been able to safely return to Bangladesh for almost 2 decades. It's also informed by people who remain in the country and Bangladeshis who live elsewhere, including here in Australia. So much of the work to seek sanctions is not public facing, so you may not have heard much about it, but we also conduct significant public advocacy to draw attention to the situation in Bangladesh. And so this includes collaborating with other civil society organisations, Bangladeshi and international, to align on messages, release joint statements, and to support and amplify each other's work. So such advocacy can be really valuable in seeking to achieve some of the impacts that are also sought by sanctions, particularly public attention and condemnation, but it can also run the risk that perpetrators are aware that they're being watched, but if they fail to experience any consequences, feel that they can continue with impunity. So a reason to continue to push for the sanctions to be used alongside such public scrutiny and calls for domestic action is to seek to see real world consequences. So the ultimate goal would be that authorities in Bangladesh no longer enable or permit an environment that allows human rights violations to occur unchecked, and that they either implement where they do not have them or use their own mechanisms for accountability. And of course, as an anti-death penalty organisation, we need to constantly ensure that all of our calls for accountability emphasise that these have to be aligned with international standards, and so that the death penalty should never be a sentencing option and that the processes must adhere to fair trial standards. So in relation to the intended impact of using sanctions that apply to individuals, many Bangladeshi officials tend to both retire to Western countries and or to send their children to Western universities, which is why personal sanctions that impose travel bans and asset freezes can be a real consequence or at least a threat. And this is, yes, assuming, of course, that they're implemented properly and assuming that the people that they're applied to do have the desire to travel and to be in these places that apply them. So, as Phil mentioned as well, the United States, they were the first jurisdiction to introduce Magnitsky sanctions in 2016, and in December 2021, they imposed sanctions against the Rapid Action Battalion. And also, as Phil discussed, despite efforts, no other country has followed suit in using their sanctions against the RAB or against anyone else in Bangladesh. We had really hoped and advocated for the United Kingdom to use Human Rights Day in December 2023 to do so, particularly in light of concerns leading up to the national elections in January 2024 in Bangladesh, but unfortunately it didn't happen. But as Phil also mentioned, the sanctions did have an impact on the willingness of international partners to work with the RAB, which had been something that was long called for. And so what is often held up as a positive example of the use of these sanctions and a reason for other states to also use their sanctions is that following the US sanctions, there was an observable decline in extrajudicial killings, particularly in the months immediately following, but also more broadly across at least 2 years. But there doesn't appear to have been the same sort of reduction in enforced disappearances, although people did tend to be brought forward for charges, whether legitimate or trumped up, rather than disappeared permanently. There were also concerning efforts to stifle freedom of expression and criticism of the government. This included arrests of members of the opposition and the deregistration of the human rights organisation AHRLA in June 2022, after having withheld the renewal of their registration for 8 years, ostensibly for publishing information about enforced disappearances and extrajudicial killings, with the publications labelled as misleading by the government. And this was then followed by the reinvigoration of criminal proceedings that had been largely dormant for years, and the conviction and imprisonment of 2 of AHRLA's leaders for their publications. So as many would know, the government led by Sheikh Hasina was overthrown last August following an uprising led by students, but not before security forces led a brutal crackdown that resulted in at least 1,000 deaths, as well as significant attempts to restrict information flow, including an internet shutdown that lasted for over 10 days. Positively, the interim government very quickly established a commission of inquiry into enforced disappearances, acceded to the UN Convention on Enforced Disappearances, and is taking steps towards establishing accountability mechanisms via new legislation. However, I note that we and other human rights organisations have raised serious concerns about the draft legislation, particularly from CPJP's perspective, that the draft includes the death penalty as a sentencing option and raises serious concerns with fair trial rights. So it would be a stretch to claim a direct causal link from the US sanctions or from international advocacy efforts to these positive steps towards achieving domestic accountability. And it would also fail to recognise the courageous efforts of people within Bangladesh. But much of our work is about solidarity and showing that people care and that they're closely monitoring what is happening. And this is really a key focus of our project. But as I mentioned earlier, international scrutiny does have a diminishing effect if nothing changes or if things get worse. And so we and other human rights groups are concerned that despite Sheikh Hasina having stepped down and the interim government being in place, that security forces have continued to arbitrarily arrest people. And it shows that systemic institutional reform is required for genuine change, not simply a change in who's leading the country. And so sanctioning, we're still pushing for sanctions against individuals within the security forces, and they still have their place. And just, I guess, quickly before I wrap up, some of the challenges we've observed in our work, I think I would agree with challenges that other people raise. So there's a frustrating lack of clarity regarding how civil society organisations can engage with the Australian government on sanctions. Most governments will acknowledge receipt, so Australia and others will acknowledge receipt of submissions by civil society organisations, but that might be the only time that you hear from them. And so it can be very discouraging and likely contributes to the view that sanctions are not an effective tool or that they are not being used effectively. And of course, it goes without saying that the impact of sanctions will be much greater if multiple jurisdictions use them. And so this is why we coordinate our efforts with organisations in other jurisdictions that have the legislation. But of course, despite Bangladesh being held up as a real shining example, only the US has used their sanctions regime so far. Another challenge that Phil touched on as well is that Australia's geographic location in the Asia-Pacific region, it presents the opportunity to show real leadership on using sanctions to address human rights violations here in our region, but there does appear to be a real reluctance from the government to use them. And the sort of oft-repeated phrase is that sanctions are just one foreign policy tool available to Australia to advance adherence to human rights, and that they would generally not be a government's first choice. So unfortunately, that understandably opens the door to the view that they're not an effective tool. But as I said, CPJP is optimistic, and I don't want to end on a negative view. So I'd say that we do still hold out hope that they're being underutilised, and that with greater use, coordination and implementation, they can deliver genuine consequences. And so we are continuing our project on Bangladesh, and we're also looking at expanding our efforts to focus on perpetrators in the Islamic Republic of Iran. So thank you. I'll leave it there.
Thank you, Elizabeth. There was a comprehensive discussion on the impact on Magnitsky sanction on Bangladesh. Just those who do not know, I'm also from Bangladesh, and I'm also a survivor of enforced disappearance in Bangladesh. And I've seen that it was pivotal in terms of reducing extrajudicial killing and enforced disappearances, and that kind of weakened the government's authoritarian grip in Bangladesh, and that opened up spaces for people to take the streets and finally get rid of the Sheikh Hasina, who fled to neighboring India and now facing crime against humanity charges in Bangladeshi uh, International Crimes Tribunal. So let us move on from Bangladesh to wider aspect of the impact of Magnitsky Act. Let me welcome our third and final speaker, Anton Moiseienko, who is a senior lecturer and research director at the Australian National University in the Faculty of Law. And he's going to present about the impact, evidence-based impact on the of Magnitsky sanction. Over to you, Anton. Thank you.
Thanks so much, Mubashar, and thanks also to Phil and Elizabeth for those excellent remarks. Before I provide a bit more background about the study that I'm going to present, I wanted to echo a couple of points that Phil and Elizabeth made and really emphasize the importance of the discussion that we're having today, because from my experience of talking to people who work on sanctions, and especially Magnitsky sanctions, there's often this moral imperative to get those sanctions enacted into law, to create the ability for governments to impose those sanctions, and then to advocate for the adoption of sanctions in cases primarily of impunity. And Elizabeth referred to that. Those sanctions are especially valuable when there's no law enforcement response forthcoming from the country where the alleged offending takes place. And when we're all gripped by that imperative of addressing truly, truly terrible misconduct, sometimes it's easy to perhaps forget or overlook or not reflect so much on that footnote to the discussion, which is, okay, so if we get the sanctions adopted, what will actually happen? And this is where I think some of that frustration that Phil referred to comes from. And, you know, it doesn't really require an awful lot of thinking to realize that in a lot of cases, again, as Phil has aptly highlighted, there won't be any assets in the sanctioning country, and the people concerned will not want to travel to the sanctioning country. And one example of that really rubbed me the wrong way and really made me a bit upset was when Alexei Navalny died in a Russian prison. The foreign minister in Australia put out a press release associating Australia, aligning itself with sanctions adopted by a range of other countries against people in that prison in Siberia who were responsible for Navalny's death, and saying, we're taking resolute steps against them. They are, from now on, sanctioned by Australia. And you think, well, okay, well, great. So are you saying that the warden of a prison in Siberia has a mansion in Manly or spends a lot of time in Melbourne? I think that's ridiculous. It's a nice gesture in a sense, but it is not much more than a nice gesture. And it's not really an effective way of addressing that misconduct. So in a lot of cases, that footnote about what happens is really, really important. So we have a realistic understanding of the role of sanctions, and sometimes it's genuinely not that much that they can contribute. On the other hand, sometimes they are pretty significant when, for example, they target people with global business interests. And sometimes even that symbolic statement of condemnation is more than nothing. And we had this interesting discussion in this series of webinars last week with Bill Browder, one of the people behind sanctions. And when he was asked the question of, okay, well, are they really that impactful? The response that he and his director of research, Vadim Kleiner, gave, a very sensible response, was to say, okay, look, they're generally not an appropriate punishment for the kind of wrongdoing that alleged perpetrators engage in. But if you have a spectrum from total impunity to appropriate punishment, at least those sanctions are somewhere in between. And so I think it's really important to have all of that in mind in this discussion. Now, where the research that Mubasha referred to comes into play is a couple of years ago, I think around 3 to 4 years ago, I was talking to an organization called the International Lawyers Project in the UK. And what we wanted to do is perhaps move a bit beyond those discussions about how one thinks in general about the effectiveness of sanctions and ask a very practical question of, if we look at Magnitsky sanctions, what actually happened to people who were targeted? So can we figure out if they lost their jobs, or if banks around the world said, okay, we're not going to ever bank a particular person, even if we're not an American bank, even if we're not directly bound by US sanctions, we're still not going to touch that person because they're so toxic. Have we seen instances of any true behavior change on the part of a broader network of government in the country affected? And so without taking up too much time, I thought I would share some slides with reflections on that project, just to give you a sense of what that research looked like. And hopefully you all see my screen now. So this is the title of the report, Global Magnitsky Sanctions 5 Years On. I think the title of the published report was a bit different, actually, but basically that's the substance of the study. And what we did is we looked at 20 people who were sanctioned for corruption. So there are two bases for global Magnitsky sanctions in the US: human rights abuse and corruption. We looked at corruption sanctions, and we looked at 20 of the very first designations made by the United States under that legislation. And then we tried to think of the different ways that the impact of sanctions could make itself felt. So one category would be direct impact, asset freezes and travel bans. So that's the direct consequence of sanctions. That's what should happen in theory to everyone. But again, we don't know that everyone had assets in the US. We don't know that everyone affected had any plans to travel to the US. So what we looked for is some indication in public reporting that those people had in fact had assets in the US and those assets were frozen, or that there was some interference with their travel routine. For example, they had a visa, permanent residency in the US, and then they can't go now because of Magnitsky sanctions. Then we looked for indicators of private sector action, banks ceasing to do business with those people, other companies saying, no, I'm not going to touch the person because they're under sanctions, media scrutiny, another component of that. The third category was developments in the home jurisdiction. So were there any criminal investigations or prosecutions at home off the back of those Magnitsky sanctions imposed by the US? Did the person lose their job? Any indicators of the diminishment of their political status? And then finally, behavior change. So did the target start doing something differently? Was there any indicator of behavior change by the broader network of government? And effectively, what we saw is that in half of the cases, so we looked at 20 individuals, we could agglomerate that into 18 case studies because 3 of the individuals were effectively members of the same family. So had 18 case studies. In 9 of those cases, we could find publicly available evidence, information, call it what you will, suggesting that some of their assets had in fact been frozen. In a couple of cases, there was indication that they would normally travel to the US regularly, and then suddenly they couldn't. And then there were a couple of other forms of consequence in some of those cases. For instance, in 3 cases, we saw criminal investigation or prosecution back in their home jurisdiction. And also in 3 cases, we saw loss of political influence. Importantly, in 6 cases out of 18, we saw no evidence of impact at all. And I want to make a couple of caveats in relation to these findings. First of all, this is our best attempt to make sense of what happened to sanctioned people. None of this is terribly scientific. There are limitations as to the evidence that we were able to work with. And in fact, one of the things that we were struck by is just how laborious the process is. So you have 20 people from all those different countries, Serbia, Dominican Republic, Uzbekistan. How do you collect that information? Well, you Google, you try your best to find openly available information. There are some linguistic barriers. So we had people on the team who could read, for example, Spanish. We had people who were able to read Russian, but even that wouldn't cover all the countries that we needed to look at. And ultimately, it's our best approximation to what probably happened in real life. And if you are a government and let's say you impose thousands of sanctions, it's really, I think, extremely difficult. And this just throws into relief how difficult it is for you as a government to then do a follow-up exercise and say, okay, let's look at what happened to the people whom we sanctioned. That would take a lot of time, even if you did draw on government resources that we obviously didn't have. But still, some of the findings are interesting. And one of the interesting findings is just the prevalence of some form of impact being felt, for example, asset freezes. But here, another factor to bear in mind is that we looked at 20 of the very first designations. A lot of them are fairly high-profile individuals. So that might color some of our findings. This might not be typical of the entire cohort of people sanctioned under the Global Magnitsky Program. And again, just to make that point very clear, we have people like Dan Gertler, a very high-profile individual doing business in the DRC, Yahya Jammeh, a former president of the Gambia, Gulnara Karimova, daughter of the now late president of Uzbekistan, members of the Gupta family in South Africa, and so on. So really high-profile individuals. Now, one of the factors that seem to be particularly associated with that important outcome of assets being frozen is this. In some cases, governments put out sanctions that effectively are a very short press release that says, Anton Moiseienko is sanctioned. Here's his address, here's his date of birth, go banks and find his assets. Now, if I'm a wealthy and not stupid individual, I'll have significant holdings via nominees, friends, family members, companies, trusts, etc. So what we saw as much more likely to be associated with assets being frozen is designations that also include information on associated individuals and companies, designations that are something along the lines of, here is Anton Moiseienko being sanctioned, and here are 50 companies that we know to be associated with him. That really facilitates the work of private sector compliance people who then try and ensure that those assets are in fact found. We saw a significant amount of coordination in that data set. Again, that probably is a consequence of the very high-profile nature of a lot of the targets. So absolutely taking note of that human rights first research that Phil alluded to. It's not typical for sanctions to be quite so coordinated, but here in this particular sample, most of the people sanctioned by the US were then sanctioned by the UK, and in a number of cases by the EU and other countries as well. Just to emphasize, that isn't necessarily an indicator of tremendous coordination in principle, probably a quirk of this data set. And then some interesting examples of there being no observable impact of sanctions at all. And what those people have in common is basically a degree of insulation afforded to them by the country in which they operate. So son of the general prosecutor in Russia, carried on regardless, from what we can tell. A couple of people in Iraq, not a country that is in any form of particular geopolitical opposition with the US, but when those specific sanctions were announced, there were high-profile politicians, members of the cabinet in Iraq who said, we're really not happy with these sanctions. They shouldn't have been imposed. And so it feels that there was a degree of opposition within the country to those sanctions, and the people involved could continue as they had continued within their home country. So that gives us some sense of situations where sanctions are less or more likely to have impact, and they're more likely to have impact if the person targeted has commercial interests around the world, or is otherwise dependent on those external actors. And I was trying to think of the Bangladesh example through that lens. And I think as you, Elizabeth, and you, Mubashir, have mentioned, there it feels that even though it was an entity of a domestic government, they still required that international support, they required training. The fact that the world, as it were, turned on them was nonetheless significant. In some cases, it's just less practically consequential for the people who are being targeted. And so there are a couple of recommendations that we made based on that report. One of them is a conceptual recommendation, and that's to say that it would be folly to only assess the effectiveness of sanctions in terms of measurable outcomes, such as the amount of assets frozen. And we felt that that might be a temptation in some cases because there are all those other categories of impact. But frozen assets are important. And to maximize that, it's important to publicize broader corporate networks and enabler networks associated with sanctioned individuals. It is important to try and target people who have known connections to the international financial system and are therefore more vulnerable to sanctions. And then a couple of designations that we looked at felt a bit like, for lack of a better term, fake sanctions, because we just spoke about how sanctions are important in the context of impunity. Now, what sometimes happens is that governments impose sanctions on people who have already been processed by their domestic justice system. Gulnara Karimova in Uzbekistan is an excellent example. She fell out of favor. She was under domestic arrest, prosecuted, convicted in Uzbekistan. Her father, who used to be the president, was already dead. He passed away. And then the United States comes in with sanctions and says, well, you're a crook, we're going to sanction you. What's the genuine contribution of that to fighting impunity, even if one were to accept the truth of the allegations, whatever that may be? So I'll stop here with just one very brief final remark that after that report, we saw some similar analysis that advances this cause of looking at the impact of sanctions from redress, which was a great report, looking into somewhat different and more categories of impact and trying to categorize them into distinct sort of buckets, rubrics of impact. And so I hope that this work on looking at what sanctions have actually achieved will continue. It feels like it's pretty important for our understanding of Magnitsky sanctions to have that baseline of a sense as to what actually happens after the sanctions are imposed. So I'll stop here. Thank you.
Thank you, Anton. That was very educative and informative presentation, and I think that will be helpful for the people who wants to understand further on the impact of Magnitsky sanction. So I will open the floor for questions from the audience very soon, but before that, I just want brief comments from Phil and Elizabeth on what Anton just presented about the impact of Magnitsky sanction. So Phil, please.
Thank you very much. I think that it's very important to understand that, it's important to have these Magnitsky sanctions. And I think that the big issue and some of the things that Anton was really getting at is how are they going to be effectively implemented? And I don't think we've answered that question yet. This is the problem where, we're literally about 10 years into Magnitsky sanctions, and there's a lack of coordination. They're not involving the NGOs the way they should in terms of, asking for inputs and assistance and understanding about potential targets and what the impacts are. We're not seeing the kind of coordination between governments that would, ensure that if one government sanctions, that other governments are prepared to immediately and systematically look at those sanctions and then follow it up. There should be a presumption that if one of the club really focus on and presents a good case, that others should follow, that it shouldn't be left to some sort of political determination, but there should be some wider coordination. I think that if we had greater coordination with civil society and amongst the governments, we would have higher impacts. We'd have more significant impacts. And I think that it's an implementation challenge that I think is the big issue here. These are hard targets. If we look at, for instance, the officials that were targeted in Hong Kong after the passage of the national security legislation in 2020, which was a Trump executive order that came out that sanctioned those persons. I'm assuming that there was impact. I'm assuming that these were global people who had assets and other things, perhaps in the US and in the UK and other places like that. But they had strong backing from a very powerful government. And so that's an element here too that is certainly going to make it difficult. In some cases, there needs to be not just sanctions on individuals, but sanctions on a government or a country. And I think that we can't just look at Magnitsky sanctions as the only way to go. I do believe, for instance, in 1990, that the comprehensive sanctions against Burma helped really create an environment where it was possible to, apply pressure and prevent the military from building out its connections and economic development of its companies that were under the military. That would have made it even more difficult for an eventual transition to take place, which did happen in 2008, 2009. So that would be my remarks. I mean, I think, yes, focus on individuals, but let's not forget that we also, in some cases, have to have wider sanctions beyond just individuals and companies.
Thanks, Phil. Elizabeth, any last remarks, please?
I think I would just say that the study that Anton was speaking to, I think it's a great way of looking at how the impacts can be measured, that there's multiple different ones, and that it's not just sort of the direct impact on the perpetrators, and that idea too that governments should also be looking at how they measure their success. It gives a very good framework, but as mentioned, for governments that do use the sanctions very, very heavily, it then is also it would be really, really hard to replicate that study on a wide scale, but it would be fantastic to see.
All right, everyone, on that note, I'm opening up this session for questioning. I have one question in the chat. Maybe Phil, you answer it first if you can, and then open it, and anyone, Elizabeth or Anton, could jump in. So this is question from Mark Mosuila Aquino. Why does Magnitsky style sanctions not given to some state forces of the Philippines, even though some government officials and agencies committed human rights violation as found out by the Commission on Human Rights of the Philippines? Sorry, yeah.
It's an excellent question, and my immediate suspicion is that it's because the Philippines is closely allied with the United States, particularly the current administration under President Marcos, and there's a reluctance to open it up. I mean, if there were certainly people who were involved in Duterte's war against drugs who should be targeted with Magnitsky sanctions, for sure. And we have not seen that happen. And I think partly it's because there's a degree of protection that's going on there, where the United States is deciding that it doesn't want to potentially upset people within its ally, especially in a wider context of the sort of new global Cold War between the U.S. and China. So this is the problem. I mean, you're talking about human rights issues don't take precedent, but political issues take precedent. And this is the undermining. So, I mean, ideally, what I would hope is that a country that is, for instance, less invested in the political situation in the Philippines, like Canada, might take sanctions against these people and then turn around to the other persons in the sort of global Magnitsky team, UK or EU or others, and say, you should take these things up as well, and put pressure on it that way. That would be, I think, a way to come out with outcome. But right now, we're just waiting for someone to take a first step. And so far, there seems to be no real political appetite to do so.
Anyone else want to respond to that question, or I could move on to the next one?
Maybe if I could just make a broader point. I think that realistically, one's got to also have some sympathy with the sort of gargantuan task that the governments have imposed on themselves by enacting those sanctions regimes, because if you have a sanctions regime that enables you to, as it were, punish perpetrators of corruption or human rights abuse anywhere in the world, you have an unlimited pool of perpetrators, not just people in your country, significant that challenge is, but people anywhere in the world. And then you inevitably have those questions about double standards. There's just no way around this. You will always have someone asking, you've sanctioned person A from this country, what about person B from that country who's even worse? And there are kind of a couple of different ways that governments deal with those challenges. One is the Australian way, which is terrible, truly terrible, which is to do nothing, and B, to say, well, we're not going to tell you what our criteria are for any of the sanctions that we do impose, because that's foreign powers' prerogative. It's up to the minister to decide, and you're not entitled to know how the minister decides. A somewhat better approach would be to have a general framework of principles. And it can be something as simple as saying, well, actually, we're going to prioritize people who are still in position of power, therefore still causing significant harm. We're going to prioritize more significant violations rather than less significant violations. And yes, we might allow some deference to foreign policy considerations. We're not going to necessarily sanction the president of a friendly country. That's realpolitik of it. But generally speaking, here are the criteria that we follow. The UK has something similar in respect of their corruption and human rights sanctions. It's got this general framework. And then finally, the other way that governments do go around this problem is if you have active interaction with civil society, which again is something that I think Australia is probably trying to build, but the US has had a significant advantage in terms of being a front runner there. If you have civil society groups submitting sanctions dossiers to you, then inevitably they will come in relation to all different countries in the world. And so if you just assess those sanctions dossiers and say, okay, well, here are those that reach our threshold of evidence that we require, you naturally are going to focus on a couple of people from this country, a couple of people from that country. So you're not targeting anyone selectively. And that's not necessarily even a consequence of your political priorities. It's just a function of all those submissions coming in relation to all the countries. So no one feels targeted. And so, sometimes people ask, well, has the US sanctioned someone from China under the Magnitsky Act? And the answer is yes, but they've also sanctioned people from all other countries in the world effectively, and that mitigates some of that political explosiveness of sanctions.
Thanks, Anton. Okay, so I have a question about Uyghurs. So Mehmet asked, how can Uyghur organization in Australia effectively leverage the Australian Magnitsky-style sanctions framework to lobby the government to impose targeted sanctions on individuals and entities responsible for the Uyghur genocide in Xinjiang? Who wants to answer this question? And it has second part, that is whether they can work with diplomacy training program, and it starts about this issue. And then third part, do you see a chance of success? So Anton, maybe you want to highlight on that?
Yeah, look, I have a sort of process-oriented answer rather than a substantive, answer as to what the chances of success are. What I would do for anyone, anyone who's got a case that they think is worthy of the application of Magnitsky sanctions in Australia, is I would talk to people who have experience of interacting with governments on those matters and have prepared sanctions dossiers and talked to governments in Australia and beyond about what a good sanctions dossier looks like. My understanding is that in Australia, the Australian Centre for International Justice would be a good organization to get in touch with, and internationally, Redress in the United Kingdom and Human Rights First in the US are those organizations who have amassed a lot of experience of actually talking to governments. So I think that rather than me trying to guess in relation to any particular situation what the best course of action is, I would just go to people who have accumulated that experience over the years and talk to them. And I think it's really important for people like the person asking that question to realize that there are those organizations around the world. And I would imagine that they would be open to contact from all good faith human rights organizations. So I would encourage to consider getting in touch with them.
Thank you. Elizabeth, if you want to contribute to that.
I would just really echo that. I mean, it's exactly what we did. We, when we started the project, we went to the Australian Centre for International Justice to get their advice. We've sought advice from Redress in the UK, and also the organisation that was really pivotal in working with the US State Department on getting the sanctions imposed in the US. So yeah, that's exactly what we do. Take advice from people who've had some success.
Thank you. There's one question to Phil. How can we, it's from Ko Salzman. He or she asked, how can we push the governments to follow their allies who supported Magnitsky law to sanction targeted people, or government, for example, Australia Magnitsky sanction to Myanmar, but not enough compared to US, UK, and EU? Why these governments not coordinate with their allies?
It's an excellent question. I don't know why they don't coordinate better. I mean, what I would hope is that, for instance, there could be some sort of collaborative between the various different sanction authorities of these different countries, getting together on a regular basis to discuss cases and discuss issues. I don't know if such a thing happens, but I've not seen it. I mean, I think there needs to be closer consultation between these various different governments. So, for instance, like what happened in Hong Kong in June 2020, when there was the passage of the national security legislation. Quite clearly, there was going to be major problems. There should have been an immediate meeting of the like-minded countries to talk about what's happening in Hong Kong, identify priority cases, and identify various different mechanisms to take action. To try to discourage the Hong Kong government and Beijing from doing more on that. And that, I think, would be the way to go. I mean, I think we're just not seeing, it's very interesting. I would say that when I talk to people in Washington who are working on Magnitsky sanctions, they tell me that the people at the Treasury Department and the other parts of the government, particularly within the Treasury Department, the Office of Foreign Assets Control, they tell me that there's very few people who are working there. They are constantly running from end to end to try to get everything done. Obviously, now with the Doge cuts, there's probably even fewer of them working there. So there's a problem that you've got too much taking place and not enough people working on it. It's not been prioritized the way it needs to be prioritized.
Thanks. Anton, I see you raised hand.
Yeah, so we do have one example of an arrangement that was created precisely to facilitate this coordination around sanctions. So that's the repo task force in relation to Russia's sanctions that was set up after the full-scale invasion of Ukraine. And one of the questions that I always have in mind is, could this not be expanded to coordinate sanctions across a broader range of topics, so not necessarily Russia sanctions alone, but it's also a cautionary tale in a sense, because the US component of that task force was something known as Task Force Klepto Capture, and it is no more. As of a couple of months ago, it was disbanded. So, even the experience of Russia sanctions, which are, I think, by far the most coordinated recent sanctions, is ambivalent. On the one hand, there was great coordination and some of the sanctions against the state as a whole, so the freezing of central bank assets is one example. On the other hand, when it comes to individuals, there are still discrepancies. People sanctioned by the US but not the EU, by the EU but not by Australia, and so on. And it's actually very difficult to get a good question, a good answer as to why. Some of the people here might be aware of a Senate inquiry that ran in Australia towards the end of last year into the Australian sanctions regime, there were a number of questions asked of Australian sanctions officials as to why those discrepancies persist. And the answer they gave is, we can't speak about this in a public forum. So, make of that what you will, but it's a surprisingly difficult challenge.
Right. So thank you. I have a question from Gashan Sahin. He is thinking I'm skipping the question at the beginning of chat. This is not fair, but I was not. I had planned to ask this question, and it was around death penalty. So I think, Elizabeth, you are better placed to answer that question. So Gashan said that, give me 1 second. So his question is, sorry, so many chats. So he said that, you are asking for ending of death penalty, but there are people who are committing crimes and, enforced disappearances and extrajudicial killing. What will happen to them if there is no death penalty? How the justice is being done? And there's one particular question about what about the implementation of Magnitsky Act in regards to the Syrian situation, lifting the economic sanctions after the overthrow of Assad regime. So I think there are two questions. One, Elizabeth, you could answer about the death penalty one, and perhaps Anton or Phil or Elizabeth, you also could jump in to talk about that lifting of sanction on Syrian situation. Thank you.
Of course. So the question around the death penalty, I may not have covered it sort of sufficiently in my introduction, but yes, our remit initially was purely focused on abolition of the death penalty, but we do recognise that that is not the only way that states kill. States also, there's state sanctioned killing, that they either enact or permit other forms of killing, so extrajudicial killings, honor killings, enforced disappearances, deaths in custody. And so that's why our remit has become much broader, because we do recognise that it's a really serious problem, and in some ways it's more problematic than the death penalty, because there's no process that's followed that you can point to and say, well, at least there was a process. But what I would also say is, and what I mentioned in our balancing of our objectives, is that there is no circumstance in which we think that the death penalty is appropriate. So we would never say that that will achieve justice. We, from a moral standpoint, from an evidence-based point, justice can be achieved in other ways. It can be achieved through, so for people who have perpetrated extrajudicial killings, they should be held responsible through the criminal courts. But that doesn't mean that a death sentence is an appropriate sentence. A period of imprisonment is appropriate, and there's no evidence that says that the death penalty is a more effective deterrent in preventing future crimes. And I don't think I can comment on the Syrian question, so I might leave that to others.
Thank you. So I'm repeating the question. What about the implementation of Magnitsky Act in regards to the Syrian situation, lifting the economic sanctions after the overthrow of Assad regime? Who wants to jump in? Phil. Yes.
It's my understanding, and again, I'm not an expert on Syria, so let me be very clear on this, but it's my understanding that the Syrian sanctions were more in the line of comprehensive sanctions. That they were not Magnitsky sanctions, or as focused on Magnitsky sanctions. And so what you have is literally, Donald Trump meets with the new president from Syria during his recent trip to the Middle East, decides that he's going to lift sanctions, and they're lifted. So, I would have to go back and look like which of those sanctions are in fact Magnitsky sanctions. Those presumably would not be covered in the lifting of sanctions, but again, I haven't read the executive order that President Trump passed. signed regarding lifting of the sanctions.
Okay. I will ask one more time if you have any question. We don't think have questions in the chat, but there's one follow-up question, but I don't think we could, keep getting follow-up question from one person. If you want to ask any question, you could unmute your mic and ask a question. This is the time now. All right. I would then pass it to Claire now. Thank you very much.
Thanks, Mubasher. On behalf of the Diplomacy Training Program and New South Wales Starts, I'd like to thank Phil, Elizabeth, and Anton for their time tonight and for speaking to all of us. It was a really useful and interesting and wide-ranging discussion, and I'm sure that those who attended today learnt a lot, and it's great that the video recording will be available as a reference and resource for other people who will no doubt be wanting to know more about this topic. And thank you very much, Mubasher, for some excellent moderating for tonight as well, and also for organising with Anton a lot of this webinar series. We're much appreciative to you both for that. As I said in the chat, both the recording, Anton's PowerPoint, and all of the resources shared in the chat today will be shared with you all shortly. Probably, well, I'm aiming for the end of this week, but it might be the beginning of next week. We've got another webinar tomorrow that I'm also working on, so I just need to see availability of time, but they will be coming and you'll be emailed all of that information as well as it being on the website. As Mubasher said at the beginning, this is the second of a three-part webinar series on the Magnitsky Acts. The third one will be sometime next week, and Anton and Mubasher will both be back for that, as well as some extra special guests. So once that registration's open for that, we'll send you an email around so you can start registering for that. I think hopefully that should be by the end of the week. Otherwise, it'll be first thing Monday or Tuesday. And I'd like to thank everybody for coming and joining us today. And I hope you have a good rest of your day, your evening, whatever time zone you are. So thank you very much.